Imagine going to a hospital or clinic with complete trust that the doctors and healthcare staff will do everything in their power to help you heal. But what if that trust is broken because of a mistake that could have been prevented? Medical negligence is a serious issue that can leave patients with life-altering consequences, and in some cases, even cost lives. Thankfully, laws exist around the world to protect patients from negligence and to hold healthcare professionals accountable. In this video, we will take a detailed look at the laws protecting patients from medical negligence, how they work in different countries, and what rights patients have when they face such situations. Medical negligence occurs when a healthcare professional provides care that falls below the accepted standard of practice, causing harm to the patient. This could include misdiagnosis, surgical errors, incorrect medication, delayed treatment, or even failure to obtain informed consent. While healthcare providers are not expected to guarantee a cure, they are expected to meet a reasonable standard of care. When they fail to do so, laws step in to protect the rights of patients. Let's start by understanding the broad principles that govern medical negligence laws. The first is the duty of care. Doctors and hospitals owe their patients a duty to provide safe, competent, and professional care. The second principle is breach of duty. If a healthcare provider fails to act as a reasonable professional would under similar circumstances, it is considered a breach. The third principle is causation, which means that the patient must prove that the negligence directly caused harm. Finally, there is the principle of damages. This refers to the compensation a patient may receive for medical costs, pain, suffering, lost wages, or long-term disability. Now let's look at how different countries have developed legal frameworks to protect patients. In the United States, medical malpractice laws are governed at the state level. Each state has its own statutes, but most share common elements. Patients can file lawsuits if they can prove that a doctor or hospital deviated from accepted standards of care. Many states also require expert testimony from another doctor to confirm negligence. Additionally, there are statutes of limitations, meaning patients must bring their claims within a certain period, often 2 or 3 years after the incident. In some states, there are also caps on the amount of compensation patients can receive for non-economic damages like pain and suffering. In the United Kingdom, medical negligence laws fall under the broader umbrella of tort law. Patients can bring claims against the National Health Service or private doctors if they can prove breach of duty and harm. One important aspect of UK law is the Bolam test, which means a doctor is not negligent if their actions would be supported by a responsible body of medical professionals, even if others would disagree. However, later rulings such as the Bolitha case refined this, stating that the professional opinion must also be logical and reasonable. Patients in the UK may also rely on the right to informed consent, established in the Montgomery ruling of 2015, which requires doctors to disclose all significant risks and alternatives to treatment. Moving to Canada, medical negligence is also handled under tort law, and patients can file lawsuits against doctors or hospitals. Like in the UK, expert testimony is crucial, and courts examine whether the standard of care was breached. Canada also emphasizes informed consent and patients' rights to clear communication about risks and alternatives. One unique feature in Canada is the role of the Canadian Medical Protective Association, which provides legal defense for doctors, meaning patients often face strong resistance when pursuing claims. Still, the courts have ruled in favor of patients in cases where negligence is clear and damages are proven. In India, the Consumer Protection Act plays a major role in handling medical negligence claims. Patients are considered consumers of medical services, which allows them to file complaints in consumer courts. This has made legal recourse more accessible and affordable compared to lengthy civil court cases. Additionally, the Supreme Court of India has emphasized that doctors must act with reasonable skill and care, and failure to do so can result in compensation orders. The Indian Penal Code also includes provisions for criminal negligence in extreme cases. In Australia, medical negligence is governed by common law principles as well as state-specific legislation. Patients must show that a doctor breached their duty of care and that this breach caused harm. Australia also applies the principle of informed consent and emphasizes the need for doctors to disclose material risks. Damages can include compensation for medical expenses, loss of earnings, and non-economic loss. However, similar to the U.S., some states have introduced caps on damages to limit the financial burden on the healthcare system. Now, let's look at some of the protections that patients enjoy under international human rights law. The right to health, recognized under the International Covenant on Economic, Social, and Cultural Rights, emphasizes that patients have a right to safe and effective medical treatment. While this is not always directly enforceable in courts, it places a responsibility on governments to regulate healthcare providers and ensure accountability. Beyond the courtroom, many countries have established medical councils, licensing boards, and regulatory agencies that investigate complaints against doctors. For example, the General Medical Council in the UK or state medical boards in the U.S. can take disciplinary action, such as suspending or revoking a doctor's license. These measures are essential because not all patients want to pursue lengthy and expensive lawsuits. Sometimes, accountability and prevention of future harm are just as important as compensation. It's also worth mentioning the concept of informed consent as a cornerstone of patient protection. Patients have the right to know the risks, benefits, and alternatives before agreeing to any medical procedure. Failure to obtain informed consent can itself be grounds for a negligence claim, even if the procedure is performed correctly. This legal principle reinforces the idea that patients are not passive recipients of care, but active participants in decisions about their health. So what happens when a patient wants to pursue legal action for medical negligence? The process usually begins with consulting a lawyer who specializes in medical malpractice. The lawyer will gather medical records, consult expert witnesses, and determine whether there is a viable case. If the case moves forward, it may go through settlement negotiations or proceed to trial. In some countries, mediation or alternative dispute resolution is encouraged to reduce the burden on courts. Patients should be prepared that these cases can be lengthy, complex, and emotionally challenging. While laws vary across countries, the underlying principle remains the same: protecting patients from harm and ensuring accountability in healthcare. These legal protections encourage hospitals and doctors to maintain high standards, adopt safe practices, and continuously improve patient care. At the same time, they provide a pathway for patients to seek justice when things go wrong. Medical negligence laws not only safeguard individual rights, but also strengthen public trust in the healthcare system. When patients know they are protected by law, they are more likely to seek medical care without fear of being abandoned if something goes wrong. To conclude, medical negligence is a complex issue, but the existence of strong legal protections gives patients a voice and a means to fight for their rights. Whether through tort law, consumer protection, human rights frameworks, or regulatory bodies, patients across the world are shielded from unsafe practices and negligence. Understanding these laws is not only important for patients, but also for doctors, hospitals, and policymakers, because accountability and transparency are the foundation of a safe and trusted healthcare system. Now that you have a clearer understanding of the laws protecting patients from medical negligence, remember that knowledge is power. If you or a loved one ever face such a situation, knowing your rights and the legal avenues available can make all the difference.